No, his witness has to leave. And, yeah, here's another bit.
So my apologies to
Thank you,
Mr.
Mr. Patterson
and others, but I lose a witness at 11, so I need to go forward. So thank you, Chair and members, for indulging me. I'd like to thank the Chair and committee for their work on this bill and accept the committee amendments. AB 2027 requires that if a victim of human trafficking has been cooperative, a certifying agency must certify victim cooperation on the applicable form so that a victim of human trafficking may apply for a T visa to temporarily live and work in the United States. A cooperative there is a definition in the bill for what a cooperative victim is, and that is a victim is cooperative to the investigation or prosecution of that qualifying committee activity if the victim has not refused or failed to provide information and assistance reasonably requested by law enforcement. This is the same definition as we had when we took up the U visas last year. This is now for the T visas. This bill also clarifies who can certify this visa as well. AB 2027 will increase public safety by encouraging these survivors to report the crimes they were unjustly subjected to. In October, this committee held a human trafficking informational hearing, and several individuals brought to our attention the lack of focus on trafficking for labor. This is why I'm introducing AB 2027. In addition to the harm that this crime causes its victims, secondary consequences of human trafficking can severely affect our own communities. The impact of human trafficking on California's communities includes child exploitation, public health problems, and depressed wages. Trafficking is an insult to human dignity and assault on freedom. I respectfully ask for your aye vote.
Okay. Any witnesses in support?
Chair and members, Jonathan Feldman with the California Police Chiefs. We are in support of the bill. We feel that as we look to partner with our communities more, their cooperation in coming forward and reporting crimes to us is definitely essential. And this bill helps us ensure that immigrants who are victims of this terrible crime feel safe, know that they will be protected if they do come forward and help assist us in identifying the perpetrators, and for that reason we are in support.
Thank you. Are there any witnesses in support? Name and organization.
Micah Doctoroff on behalf of the ACLU of California in support.
Thank you. Are there any other witnesses in support? Are there any witnesses in opposition?
Asha Harris on behalf of the California State Sheriff's Association. While victim cooperation can be extremely valuable in a criminal investigation, we are opposed to the notion that this bill would take away sheriff's discretion. We do not like this because it limits our discretion, and so we want to be able to continue to go on with these investigations as we've been doing. And with that, I'm respectfully opposed.
I think everyone in here heard you, but maybe not outside this room.
Should I repeat that?
Thank you. Are there any other witnesses in opposition? Okay. Are there any questions from committee members? None. You may close, Mr. Quirk.
Move the bill.
Okay. Chair's recommending an aye. And the second? And the chair's recommending an aye vote.
AB 2027, the motion is due pass as amended to the Judiciary Committee. Jones-Sawyer?
Aye.
Jones-Sawyer, aye. Melendez? Melendez not voting. Lackey? Aye. Lackey, aye. Lopez? Lowe? Lowe, aye. Quirk?
Aye.
Quirk, aye. Santiago?
The bill is out. Mr. Lowe got here just in time.
All right. Thank you.
And Mr. Patterson, thank you for your patience. I appreciate that. The committee appreciates it. And it's 2427, item number 26.
Glad to defer to any members if it will help me get a yes vote on a couple of things. I'd be delighted. We will see. Thank you. Thank you, Mr. Chair and members, for the opportunity to present AB 2477. Here's what we're trying to do with AB 2477. Try to clarify that the court will retain jurisdiction over a case for purposes of restitution even after the probationary period expires. California's Constitution guarantees a victim's right to restitution from a convicted wrongdoer. Two state appellate court decisions have set a precedent that the court loses jurisdiction to impose restitution after the defendant's probationary period has expired. Oftentimes, when a criminal is found guilty and sentenced to a probationary period, they are also sentenced to pay restitution to the victim as well. The problem is created because the amount of restitution cannot always be determined at the initial court hearing, because sometimes a victim's losses can be ongoing, such as in the case with ongoing medical bills, etc. There are also cases where restitution was determined early, but that restitution needs to be corrected later on. Situations like these prompt a separate restitution hearing. So, members, as a constitutional right, the payment of restitution should not be predicated on the probationary period, nor should the court's ability to ensure accurate restitution be predicated on the term of probation. Accurate restitution should be paid to the victim regardless of when the term of probation expires. So what we're attempting to do here is to separate the probationary period and the payment of restitution. By doing so, we will ensure that victims receive the full restitution that they deserve. AB 2477 will uphold the California Constitution. It will ensure that victims receive the restitution that they are entitled to. What we're doing here is making sure that victims receive restitution even after probation expires. I appreciate the opportunity to introduce Sean Hoffman. He will testify about this particular item and hopefully bring some clarity to it.
Thank you, Mr. Hoffman. 2 minutes.
Sure. Thank you, Mr. Chairman. Members, Sean Hoffman with the California District Attorneys Association. We're the sponsors of AB 2477. This bill would give courts the jurisdiction to modify or impose restitution orders after the expiration of supervision in order to preserve, as the author stated, the constitutional right of restitution for every victim who suffers an economic loss. So current law provides that if a victim's economic losses can't be determined at the time of sentencing, the court retains jurisdiction for the purposes of modifying and imposing that restitution order until the losses can be determined. Recently, in the Hilton v. Superior Court case, the 4th District Court of Appeal held that the court loses jurisdiction to modify or impose that order once probation expires. So prior to the decision, common practice was the court retained jurisdiction for the limited purpose of modifying or imposing restitution. The law provides elsewhere that restitution orders survive the expiration of probation, but the holding in Hilton precludes a court from going in and ordering or modifying the restitution amount. So you could have a situation where the restitution order has been issued, probation expires, and the court wants to go in and change the amount, perhaps reduce the amount of restitution. They'd be precluded from doing so under this decision. So, and we believe this is contrary to the California Constitution, which requires a restitution order in every case, regardless of sentence or disposition. And then you've got the Victims' Bill of Rights and Marcy's Law, which support a court's continuing jurisdiction to deal with these victim restitution issues. In the vast majority of cases, the victim restitution amount is going to be finite. We'll be able to determine that before or at the time of sentencing. But there are at least 3 scenarios where the court needs to be able to go in and take a look at these issues post-supervision. One, when it's discovered that the victim restitution was overlooked. 2, when it's discovered that the amount was incorrect and either needs to be increased, reduced, or eliminated altogether. Or 3, when restitution was contemplated by the parties but supervision expired before the order could be submitted. AB 2477 would provide the flexibility necessary to deal with these issues post-supervision. We ask for your support.
Thank you. Are there any witnesses in support? Name and organization.
Mr. Chair and members, Corey Salzillo on behalf of the California State Sheriff's Association in support of the bill.
Thank you.
Good morning. Usha Machler on behalf of the California Probation, Parole, Correctional Association in support.
Thank you.
Jonathan Feldman on behalf of the California Police Chiefs Association in support.
Thank you. Are there anyone testifying in opposition? Thank you. You have 2 minutes apiece.
Micah Doctoroff on behalf of the ACLU of California. Here in respectful opposition to AB 2477, this bill seeks to expand indefinitely a court's jurisdiction to impose restitution. We believe that such an expansion would run afoul of the careful limits on courts' control over defendants, and we think that it could threaten the longstanding principle of finality of judgment. Under existing law, a trial court loses jurisdiction over a defendant once the defendant's probationary term expires. This concept is grounded in statute and has been reinforced by case law spanning nearly 50 years. More recently, courts have found that trial courts likewise lack jurisdiction to impose restitution once a defendant is no longer on probation. These statutes and court decisions reflect California's long-standing interest in finality in criminal cases. This interest serves not only defendants, but prosecutors, victims, and courts alike. Placing limits on courts' jurisdiction over defendants also reflects California's long-standing commitment to ensuring that criminal defendants do not remain under criminal justice control in perpetuity. There are already more than 1,800 collateral consequences associated with a criminal record in California with which defendants have to contend. For these reasons, we respectfully oppose the bill.
Thank you.
Good morning, Chair and members. Dennis Cuevas Romero on behalf of the California Attorneys for Criminal Justice in opposition. We feel that this legislation not only overturns current case law, but the current law encourages a claimant to use diligence in presenting a claim for restitution. It also provides an incentive for a defendant to satisfy a restitution order to the expiration of probation in order to prevent the probation term from being extended to satisfy the debt. It further incentivizes a defendant to pay restitution early in his probation term to support the request for early termination. For these reasons, we think it's contrary to current case law and the above-mentioned goals and incentives. For these reasons, we're in opposition.
Thank you. Witnesses in opposition?
Khalif Asagay with the California Public Defenders Association, also in opposition for the reasons previously stated.
Thank you. Is anyone else in opposition? Committee, any questions?
Might I
You may
address
close.
very quickly?
Did you?
I think with respect to the ACLU's concern over unlimited jurisdiction, I concur with that. And we were willing, and I thought we were in some discussions about limiting this to 5 years as an amendment that we were willing to take. My understanding was that the committee essentially thought otherwise. But I wanted to put back on the table here the potential for a pathway where we could get support from the opposition and also from the committee if instituting the 5-year limit. The District Attorneys Association also concurs in that as well. The other issue I think here is that I think it's important that when that the individual should be able to get on probation, right, and finish up the probation and get into a better life and a better place. And so what we're trying to do is at the same time that takes place, there does become a period which we fix the consequences of the court cases that have led us to the place where we are presently. So I think this, with reasonable amendment with respect to length of the jurisdiction and an understanding that the consequences of these court decisions has created a real serious problem. And the real serious problem is that it is possible for the individual to go off of parole and then have absolutely no recourse by the victim to be able to try and persuade the court that there is some other considerations. I also want to point out that this can work conversely. In other words, the period of time to discover and learn about the award can actually be reduced when more information and when more time is presented. So we think this is a very good balancing act, and particularly with the 5-year time period, we're glad to accept that if that helps move the bill.
Okay. Thank you. That's just close. Did we get a? Okay, it's my understanding. I understand where you're trying to go. I think from the committee's standpoint, on the 5 years that currently, and the court has the opportunity to do that anyway, and this notion that once you finish, there's this thing where people say if you do the crime, you got to do the time. Well, at some point, it's got to end. And when you're off probation, when you serve your time, it just really has to end so you can begin your life. And really to have this sword of Damocles hanging over your head. Right now, the way the bill is written is indefinite. And so I think you're right, maybe with some more conversation trying to get to where you're going to. It may not necessarily be this mechanism. And so I'm recommending a no vote on this. But I do believe you're earnest in what you're saying, that you want to try to figure something out with the opponents and with the committee staff to come up with something. So I'm going to recommend a no vote, and I will sit with you if I have to, if it doesn't make it out of here, to try to come back with something that actually makes sense.
Would it be a wiser approach to simply hold this over, have some conversation about this? And
I'm not sure we can do it in a week. That's the challenge.
I'm okay. Again, I'm willing to put the 5-year on the table immediately, and we can do that in a week. If that's not sufficient,
the calendar is like jam-packed. We have 90 more bills, and I probably put over how many today? 7 today. And so unfortunately, this is something we may not even have the staff time to really go through. I'm just being totally honest with you, Mr. Patterson, because I totally respect you.
I appreciate it. And I'm trying my best to work a way here where we can get the restitution to these individuals, but also let these probationary people turn their life around and get off it. We can do it simultaneously, and I think we can find a way.
Too, so.
Pardon me?
If it doesn't make it out, you can always do reconsideration. So, go with Madam Secretary.
AB 2477, the motion is due pass your appropriations. Jones Sawyer?
No.
Jones Sawyer, no. Melendez? Melendez, aye. Lackey? Lackey, aye. Lopez? Lopez, no. Lowe? Lowe, no. Lowe, sorry. Quirk?
No.
Quirk, no. Santiago?
It's on call.
Thank you, sir. If it does fail, would request reconsideration. Thank you very much.
Be granted. Mr. Levine, I thought I saw him in here. Mr. Levine and Mr. Thurman.
And Mr. Lowe.
And Mr. Lowe, who's...
He stepped out. We'll get him.
Well, we need him more than you do. We need it to vote.
Thank you, Mr. Chair and members. I'm honored to join Assemblymember Thurmond and Assemblymember Lowe in presenting AB 2262. This bill will give courts discretion during sentencing to consider mental health treatment. For for individuals who are diagnosed with a mental illness. How we address mental illness in the criminal justice system has become critical to improving public safety. Several weeks ago, Governor Brown announced that he would pursue an initiative to address the unintended consequences of our mandatory sentencing laws. I applaud Governor Brown for his leadership on this issue fully agree that we need to address our prison overcrowding crisis immediately. One unintended consequence of mandatory sentencing is the large number of mentally ill people who are currently behind bars. In the last 15 years, the number of mentally ill prisoners has almost doubled. Today, it is estimated that half of all California prisoners have a diagnosable mental illness. In fact, 10 times as many mentally ill people are in prisons and jails today than are in mental health treatment facilities. As a result, our jails and prisons have become de facto mental health facilities. The Los Angeles County Jail has been called the largest mental health provider in the country. In many cases, mentally ill prisoners come from underserved communities where there is tremendous violence, higher rates of mental illness, and minimal mental health services. We also know that mental health conditions worsen behind bars, and that without treatment, the rate of repeat offenses is much greater. There can be no doubt that failure to consider mental illness in sentencing has exacerbated California's prison problems. To address this, some counties have created mental health courts. In these counties, mental health court participants have significantly lowered recidivism rates, often reintegrating into their community in a productive way. This has resulted in a savings of $7 in corrections costs for every $1 spent on mental health treatment. This situation presents us with a real opportunity to use what we have learned about effective investments and treatments. AB 2262 allows California to be much smarter about how we tackle mental illness in our criminal justice system and reap the short-term and long-term benefits. On the whole, when those with mental illness get treatment, they get better. The resulting improved outcomes equal notable cost savings. Under existing law, when an offender is convicted of a crime, courts currently consider the length of sentence. AB 2262 will give courts the option of requiring mental health treatment as part of an offender's sentence. This would only apply when there is no threat to public safety and is in the interest of justice. And I would like to introduce the joint authors of this bill, again, Mr. Thurmond and Mr. Lowe.
Through the chair, thank you, Mr. Chair, members of the committee. Simply want to express my support, along with my joint authors, Levine and Lowe, in support of AB 2262. I would align myself with the comments that you heard from Assemblymember Levine, that we know that nearly 50% of those who are incarcerated have a mental health history and mental health conditions. We also know that these are individuals who are more likely to return to crime and recidivate if we do not provide them with mental health treatment. There are those who would invite you to think of this option that we'd be providing to our courts, to think of that as being soft on crime. I would like to invite you to resist that kind of thinking and instead to think simply about the ability to make sure that we can prevent recidivism from those who we know will cost Californians, will cost themselves and their families by continuing to enter into our criminal justice system. By way of context, I would say I've spent 20 years working as a social worker, working in various communities, including the mental health community, with youth and adult. Nearly every individual that I've worked with who had contact with the criminal justice system had some form of mental health experience, had experienced trauma, and if we don't get serious about how we treat that, then we will find ourselves seriously continuing to pay for the lives of broken individuals and families because we're using our prisons as a mental health center. We simply ask that you give the courts the option to say that someone with a mental health history who does not pose a threat to the community can be treated in a mental health residential treatment facility. I respectfully ask for your aye vote.
Thank you.
And just, if I may, Mr. Chair, before I introduce those in support, I would just like to point out and acknowledge the suggested technical amendment in the committee analysis on page 7. We would be happy to amend the bill in the Appropriations Committee to clarify that if a judge resentences a defendant, that the court may not impose a longer sentence than originally imposed. The other point, as I introduce the testimony in support, is that these are co-sponsors. With us today, in support are Michael Romano, the director of the Stanford Law School Three Strikes and Justice Advocacy Project, and the other co-sponsor is Anna Hasselblad, who is the public policy director of the Steinberg Institute.
Thank you. You each have 2 minutes apiece.
Good morning. My name is Anna Hasselblad with the Steinberg Institute, and we are proud co-sponsors of AB 2262. The Steinberg Institute was founded by Senator Gerald Steinberg, and we are dedicated to advancing sound public policy and inspiring leaderships on the issues of mental health. We are committed to finding a solution that alleviates jails and prisons by way of ensuring that people living with mental illness receive the care they need when they need it for as long as they need it. AB 2262 by Assemblymember Levine, Thurman, and Lowe will go a long way towards improving the outcomes for offenders with a mental illness and breaking the cycle of criminal involvement. The rates of prisoners, as mentioned, who live with mental illness has dramatically increased in recent years, accounting for 50% of the state's prison population. Not surprisingly, many of these offenders' crimes were directly linked to their psychiatric condition and the lack of appropriate treatment. According to the U.S. Supreme Court, conditions in California prisons exacerbate psychiatric disorders of prisoners with a mental illness. Additionally, when released from custody, parolees with a mental illness who did not receive mental health treatment have a higher recidivism rate, creating a revolving door of high-cost individuals remaining in the criminal justice system and not accessing the treatment they need to become productive citizens. AB 2262, the Mental Health Justice Act, addresses this issue by allowing superior courts discretion when sentencing an offender with a mental illness to include mental health treatment in the prison sentence and at community jails when it's in the best interest of the defendant and the community. This doesn't mean that offenders won't serve time in prison and jails. Many still will. It just means that with an additional proper treatment, they have a significantly better chance of not returning once released. We respectfully ask for your aye vote on AB 2262.
Thank you.
Hi, my name is Mike Romano. I teach at Stanford Law School. I'll be brief. First of all, I wanted to, just as a procedural matter, note that we sent a letter to the committee. It didn't get into the analysis, but I think you all have a copy, and I'm happy to provide additional ones if necessary. The only thing that I'd like to add to what everybody else here said is that there's even a recent projection by the Department of Corrections that despite the reforms of sentencing, despite the prison reduction population in California, the population of mentally ill offenders in California continues to go up. They're projecting that they need to build more beds and more hospital services for folks who are mentally ill. So whatever that is that we're trying to solve, the problem is just keeps on getting worse and worse. All the evidence that's out there today suggests that this type of treatment instead of incarceration will reduce recidivism, improve public safety, and reduce costs. To those who say that this bill doesn't go far enough, I would say that I agree, but it's a modest step in the right direction. To those who say it goes too far, I just emphasize what was said earlier, that this is purely discretionary. A judge who does not want to go along with this project does not need to go along. It requires nothing of anybody. It's just for a judge who has a defendant in front of him who thinks they can benefit from this type of treatment. Thank you.
Thank you. Are there any witnesses in support? Name and organization.
Kieran Savage, National Alliance on Mental Illness of California, in support.
Thank you.
Sharon Riley on behalf of the Judicial Council. We do recognize the issue with mental illness and incarceration. We do have, however, some concerns about the existing language. We've conveyed them to the author's office and the sponsors, and we look forward to working with you in the future. No position at this time.
Thank you.
Move the bill.
Any witnesses in opposition?
Good morning, Mr. Chair, members. Sean Hoffman with the California District Attorneys Association. Unfortunately, here in opposition today, we have had some productive conversations with the author's staff and hope to work with them as the bill moves. Our opposition really boils down to 3 points. One, we have concerns about putting a judge who's not a mental health expert in the role of determining whether this person's mental health issues are such that they should be sent into a residential mental health treatment facility or into some other type of programming at either the county jail or CDCR level. And to that point, we don't believe that these programs exist in enough of those facilities to feel comfortable directing these people into programs that may or may not exist at this point. We'd rather see that infrastructure in place before we start sending people there, kind of a if you build it, they will come model, rather than if you send them there, we'll have to build it model. And then finally, we think that the unreasonable risk of public safety, the determination that would be made whether this person could go to a residential mental health treatment facility, is based on a really unreachable standard that's in the law. Not to sidetrack this, but something that went in with Prop 47 that defined unreasonable risk of to public safety as an unreasonable risk that this person is going to commit one of a very narrow subset of violent offenses. Those would be the only disqualifying offenses from sending someone into a lower security residential mental health facility. We think that is poor public policy, but we look forward to continuing to talk with the author about our concerns. Thank you.
Thank you. Are there any other witnesses in opposition? Any questions from committee members? Mr. Lowe.
Thank you very much, and I'd like to thank my fellow joint authors. What you're seeing is the result of a number of conversations with many stakeholders involved and individuals who have a background and expertise in this area. And what I think is important to recognize is this bill focuses on the flexibility of addressing mental health and addressing it. It's a first step, a long way to go, but it's an opportunity to allow that flexibility. As previously stated, it's not a mandate, but allows for the option to consider this, and I respectfully ask my fellow colleagues on this committee to support this.
Thank you. Mr. Quirk?
Yeah, this is long overdue. I'm hoping the DAs will find a way to support this down the line if there can be some sort of adjustment here, but I support this 100%. We'll be voting for it on the floor, and as you said, the LA jail, the biggest purveyor of mental health in the country, is just an abomination. And we see the problems with the prisoners, what happens to them, because, frankly, no matter how well you train a deputy sheriff in a jail, they're not able to cope with this. And so I think it will be better for all those around if we can start to move in this direction. So, again, you have my 100% support.
Any other questions? You may close, Mr. Levine.
I will take Mr. Lowe's comments as our close.
Okay, thank you. The chair is going to recommend an aye vote, and I'll put it in this context, and hopefully the DA's office will work with you on moving forward. Yesterday, someone with obvious mental problems attacked the Capitol. It's now coming out that he had been in the building several times, shouted during committee meetings, obviously had some mental health challenges. And I think because of the law enforcement there, they didn't know how to handle it. I think we've buried our head in the sand too long, to where we just left things alone, to where it exacerbates, to where you have one of those incidents. Now, normally, this wouldn't bother me, except that the Capitol office that he tried to enter into, my son was in the gift shop at the time. And if it wasn't for the swift action of the Capitol Police, I don't know what would have happened. And I'm saying that to say we've got to do something. And I have a feeling there will be a lot of scapegoating about what happened. Why didn't law enforcement do enough? They shouldn't. They did all they could with the tools and the things that they had at that time, and it's now time for California maybe to lead the way on mental health and how we deal with mental health and the criminal justice system. Because if we don't do it, I don't think anybody else will. And so I'm asking everyone to do an aye vote.
Thank you, Mr. Chair.
Yes.
AB 2262, the motion is due pass to appropriations. Jones Sawyer.
Aye.
Jones Sawyer, aye. Melendez. Melendez, no. Lackey. Lackey, aye. Lopez. Lopez, aye. Lowe. Lowe, aye. Quirk.
Aye.
Quirk, aye. Santiago.
That bill passes. Congratulations.
Thank you, Mr. Chair and members.
Mr. Irwin. Oh. Probably not. Well, actually, you probably could, but I'm not going to tell you who.